All attendees are in listen-only mode.
Okay, welcome everyone to our webinar, the TaxLinked webinar on the UK's Persons with Significant Control Register. We have a very esteemed guest of panelists with us today. Let me get some admin issues out of the way to begin with. Those people who are attending, feel free to ask questions on the control box, control panel that you have on your screen. There's a section for questions. Please feel free to submit as many as you like, and I'll try to incorporate them into the discussion. This webinar is being recorded. We're not filming it, but we're recording the audio, and we will release the recording probably within a week, and we should have a transcript ready for everyone in 2 to 3 weeks' time. The transcript I will also blog about, and I'll share with everyone via social media. So keep an eye out for that. With that said, I'm going to ask each one of the panelists to introduce themselves, tell us a little bit about themselves and about their interest in the PSC register. So I guess let's start alphabetically by last name. Let's go ahead and start with Nicholas. Please, Nicholas, the floor is yours.
Hi, I'm Nick McVeigh. I'm a corporate lawyer at Mishcon, Reya, and I work in the know-how team in our corporate department. So a couple of years ago I moved across from a fee-earning role into the knowledge role. So day to day I'm involved with sort of updating the other lawyers on legal developments, drafting articles and briefings for clients, training other lawyers, and generally sort of keeping on top of legal developments. So the PSC register is something that I've been very interested in as I've been following the topic of corporate transparency over the last couple of years and how it's evolved and developed, and very interested in sort of discussing it today as the sort of transparency picture is still evolving and still moving forward.
Excellent, Nicholas. Nick. Femi, please.
Oh, hi, everybody. My name's Femi Ogunshakin. I'm a tax advisor primarily, but recently qualified as a solicitor. I am chief executive of a group of companies called Loftus, Stowe, and we cover both taxation, accountancy, HR, as well as touching on some areas of legal issues where it impacts on clients within the group. I have a particular interest in the PSC because I followed it from when the bill was first discussed in Parliament, and then sadly spent most of the Easter of this year looking through the papers that came through. Frightened me enough to call a team meeting straight away, straight after Easter, which didn't go down lightly, to sit down with my team and my co-directors to start talking about how we were going to roll it out to our client base. So in a nutshell, I'm here today to talk about how it's impacted on our clients, who are effectively small to medium-sized businesses. Indeed, some are micro businesses.
Excellent. Peter?
Okay, Mateo. I'm Peter Wilson. I'm an international tax partner at Simmons Gainsford in London and recently Dubai. My interest is wholly and solely in international tax, and interested in the PSC register, I suppose, to see how it links into the automatic exchange of information under the CRS system, and looking to see whether there may be some differences in definitions, certainly in control, to see whether it's possible for you to have an economic control which is not a legal control. So that's where I'm involved.
Excellent. Okay, so let's get started with the list of questions. A lot of these questions are basically background information on what the PSC register are, and later on, I guess we're going to get into a deeper discussion on some of the issues that we have been touching upon right now. So to get started, Femi, what has the response been so far from clients and professional colleagues vis-a-vis the UK PSC register?
Well, I'll tell you something. It seemed to have caught quite a few people by surprise. My accountancy colleagues seem to think that it's a function of corporate law, so they didn't particularly spend much time with it. So they didn't necessarily update their clients and tell them that they had an obligation. Because we're multidisciplinary, I was able to convince my colleagues that it would be in our best interest to tell our clients But stepping out of the office and talking to other accountants, I found the same sort of level of knowledge was, well, it's not really our area, it's for you lawyers to deal with. So come back to the office and then get back out to clients and start talking to them. A lot of them had never even heard of it. They thought if they did their annual return, that was sufficient to disclose who owned the beneficial interest, well, not the beneficial interest, the the actual legal interest in the company. So we had to actually explain to our clients what it was, what the register was, what they were obligated to do, what the consequences of failure to comply would be, and a lot came out of the woodwork. We got a lot of questions. We actually found out a lot about who actually owned these businesses, because people generally speaking came forward to say, in actual fact, we should probably tell you now that we have a shadow director, someone controlling from from the sidelines. So it has been interesting, and do remember that we only started talking to clients when it became obvious to us that by the first, I think it was early April, that owners of businesses were meant to create the register. And it's 30th of June going forward that they have to, they have to start submitting, along with their confirmation register, they have to start submitting information to Companies House. So it's taken a lot of our small business owners quite a bit of time to get used to the concept.
Okay. Excellent. And Peter, what about like an international context? I mean, how have your clients reacted to the PSC register, or what can you share with us on that front?
I think the only place where we have seen it, or where I have seen it, is for international people who have established foreign companies or non-UK companies to own UK residential property. They're the people who have normally been trying to hide behind companies either directly or indirectly, and there seems to be a lot of interest in that. I know in our firm there's been a lot of effort getting information from people and putting it into registrable form, but I suspect that we've probably got another 3 to 6 months before there's a real problem. Although I must admit that last week I got a request to write an opinion on this from one of the big 4 accounting firms actually in Cyprus, who seems to represent a family who own a UK company with some major international undertakings underneath it, and the big 4 firm has suddenly got quite cold feet about what it should actually be doing here. So we're just waiting to see how interested the family is in bringing their register up to date.
Excellent. Nick, what about your case?
Yeah, I mean, similarly to Femi and Peter, we have been trying to sort of give clients a heads up in advance and sort of help them to sort of gather the information and do the analysis. And I think people have found that, and we'll get on to the detail of some of the regime later, but it's not always a straightforward analysis. It can be quite complicated, and I think clients and sort of fee earners within my team have found it useful to have a sort of second opinion on some cases where arguably some of the legislation there is room for ambiguity. I think it's been interesting to look at the application of the regime on different fact scenarios and sort of work through that with clients. A big part of the work that we do in corporate here in Mishcon is M&A, so it's something that, given that it affects the vast majority of UK companies and LLPs, it's something that we've got to be thinking about not just when those entities are created, but also on an M&A deal when there's a signing or completion, and there's a change of legal ownership. We also need to be thinking about what is the impact on the PSC register at that point. So it's something that people will need to be familiar with and sort of continue to keep up to date with as market practice evolves around it.
Excellent. Okay, so let's with that kind of getting a feel for what clients and other colleagues are, how they actually receive the PSC register. Let's get into the didactic portion of our event, and let's actually let's see what the PSC register actually is. So let's get started. What is the PSC register? Where is it kept? And what information goes into it? Femi, you want to start us off with that one, please?
Yeah, happily so. Again, I'm going to give you the perspective from the fact that we're dealing with much smaller clients, so I'm sure it's complex at other levels. But basically, what we're saying to our clients in a nutshell is that if you are a beneficial owner, we need to know. But more to the point, if you own, if you're a shareholder to 25% or more, then you need to be on the register. And that in itself is bringing out all sorts of questions from clients, but essentially we are saying to them, if you control the affairs of a England and Wales registered limited company, then you should be on the register. But if you own 25% or more of the shares in the company, you should be on the register too. It's been quite fascinating, as I said, as to the responses you get when you take that to clients and say, these are the people who need to come forward. We need to be able to identify them. We need to tell them. We need to register them. And that's the message that we're sending out.
Okay. Where is the register kept, and what information, what precise information goes into it? If we're looking more at the details.
It's relatively straightforward information, to be honest with you. It is, name, date of birth. It's all the usual personal information you'd expect to find on say, an annual return. What's interesting here is that you're now putting down the percentage ownership of the individuals, and you're also disclosing who has a controlling interest. So I think what makes it different is that you've not just repeated what you put down when you incorporated the company, if nothing has changed. You're actually now disclosing who has a beneficial interest in the business. As to where it's kept, it should be kept at the registered office, which again brings up its own issues, because what if the registered office is the accountants or the lawyers? But it must be registered with Companies House as well. It's early days. Most of our clients have submitted theirs to us to keep for them, while they keep one on their statutory records in the office. We're not sure what compliance is going to be like yet, but we're saying to clients, well, we'll hold a copy, you hold a copy, and when it comes to time to submit your confirmation statement, formerly known as an annual return, Companies House now has on its database for all to see, it now has a new entry on it which actually shows persons with significant control register. So what would be interesting going forward is if you're using Companies House WebCheck beta system, for instance, which is freely available, you will see who the directors are, you will see who the persons with significant control are, as well as seeing the usual things like the accounts and the registered office and details of everything else that's registered. So primarily kept at the registered office of the company, but there is a statutory obligation for it to be uploaded to Companies House.
Excellent. Nick or Peter, anything to add to what Femi has mentioned?
Not from me, not from me.
Not at this stage. I mean, I think one point that's worth mentioning in relation to the location, as Femi says, you can keep it with your other statutory books at your registered office, and then you file the information as part of your confirmation statement. There is a new option that's just become available from the 30th of June, as you probably know, to maintain some of your statutory registers at Companies House centrally rather than maintaining your own statutory books. And if a company went down that route, then you would need to be updating your PSC information directly at Companies House, sort of in real time, rather than as part of your annual confirmation statement. But I think it's very early days with that new regime, so I don't know how popular that's going to be at this stage.
Okay, and I know we've touched upon this a little bit, but what are the conditions for PSC status, or who does the PSC regime affect, specifically speaking? Nick, how about you?
So
let us know about that.
Yep, as Femi says, it's based around control, but there are 5 conditions for PSC status, and someone will be a PSC if they trigger one or more of those. And broadly, those are holding directly or indirectly more than 25% in nominal value of the share capital of the company, or in the case of a LLP, holding rights to participate in more than 25% of the surplus assets in a winding up. The second condition is holding 25% or more of the voting rights in the company or the LLP. The third one is holding the right to appoint or remove a majority of the board of the company, or in the case of an LLP, a majority of the management. The fourth condition is having the right to exercise or actually exercising significant influence or control over the company or LLP. And the fifth condition is having the right to exercise or actually exercising significant influence or control over a trust or firm that in turn satisfies one of the other PSC conditions. And as I mentioned, those first three conditions can be triggered directly or indirectly, and that's something that Peter touched on earlier. And we're looking at whether they've been triggered indirectly. That would be the case if an individual held a majority stake in a legal entity that satisfied one of the PSC conditions. And a majority stake is defined in the legislation, and there are 4 limbs. And again, it's broadly if you hold a majority of the voting rights in that intermediate entity, or secondly, if you are a member and you have the right to appoint or remove the majority of the board. Thirdly, if you're a member and by agreement with the other members, you have the right to control the voting rights. And fourthly, if you exercise dominant influence over the intermediate entity. So it's you've kind of got 2 stages when you are working out if a PSC condition is triggered. If you're looking at individuals holding directly, you go through the 5 tests where the reference points are 25%. But if you're looking through a chain of entities, you need to have the majority stake concept in your head to see whether whether someone higher up the chain satisfies a condition indirectly by having a majority stake.
Excellent. Femi or Peter, anything to add to the conditions for PSC status?
No, not at all, no. It just brings home the point about control, though. At the level at which we're operating, we do see a lot of people who, for reasons best known.
Femi, you're breaking up. We can't hear you.
This control issue, this idea that they have a signal, they're aware of it. They've always been aware of it. It's asking me to hide the webcams, but I don't think I will. Are you still there?
Yeah, we're here.
Right. Okay. Well, sorry. All I was going to say is that what this, you can hear me now. It's just brought to the fore this idea of control, not necessarily control by way of ownership of share capital itself, but by people with reasons which sometimes have nothing to do with criminal or nefarious activities. It just boils down to sometimes commercially people want to not be as transparent as they could be because they have reasons of their own. So nothing more to add to what Nick has said, but generally speaking it just sharply focuses on this idea of controlling companies, not necessarily for reasons that the legislation has been put in place, and it creates some steering in the commercial market, which we're having to deal with now.
From my viewpoint, there are some really interesting issues here, because when you look at some of the countries around the world that are doing something similar in their tax system, you'll see some of them will say that significant control can be exercised through a vast number of operational means, and some of the operational means they address include who is whether the person, sorry, let me start again, whether there is a person who has control of supplies of raw materials to a second person, whether that gives the first person control. You'll see some things like whether the equipment that the second person uses in their business, which is owned by the first person, gives the first person control over the second person. You also see in some countries where the second person is actually a manufacturer and the manufacturer is using intellectual property, the country will determine that the provider, the grantor of the intellectual property to the user, can be perceived to be the controller of the second person as well. So I don't think in the UK that has actually got to that point, but you can imagine the complexities that will follow if the register, or if the provisions are expanded to take into account normal commercial transactions along those lines.
Yeah, yeah, absolutely. I'll say just very quickly now that I'm actually stunned. That analysis is absolutely brilliant for starters, but secondly, heaven forbid taken to that extent, because that's the point I was making earlier on. Some of the clients we're talking to are saying for commercial reasons they need to hold back who actually is the beneficial owner of the company, because they need to launch a product, but actually they don't want to give the competition heads up. So they want to get into the market first, build up some capacity, and then hit it running. So, but I've never thought in terms of who owns the machinery, which then enables company B to actually get what it needs done, that they could be conceived to have significant control. That's a very interesting point.
Well, yeah, these tests are just a few of a very wide and extended definition of associated persons in the Indian and Chinese transfer pricing rules and thin capitalisation rules. And what I've given you is just a succinct beginning of the first sentence almost of what parades as an amazingly wide definition in those countries.
Mm-hmm. Yeah, it's interesting because in the, as you probably know, in the statutory guidance that was published in relation to the fourth and fifth conditions here in the UK, they do actually talk about suppliers and customers, and they sort of say that ordinarily someone who's a supplier or customer, that's not going to sort of make them someone with significant control or influence of itself. But it does make the point that you need to sort of look at the whole picture, and if someone is exercising a greater degree of control than you would ordinarily expect a supplier to be exercising, then that may well put them into the category of a PSC. There's a list of accepted roles, and that includes suppliers, lenders, customers, people who are acting in a professional capacity, such as lawyers or accountants. But the guidance is very clear that if the person is going beyond what you would ordinarily expect that relationship to entail, then they may be a PSC, and you need to sort of look at whether that is only one of several opportunities they have to exercise control over or influence the company. So it goes back to that point of having to look at the whole factual matrix, and that's why I think there are some grey areas, or there are certainly areas where a judgment will need to be made as to whether the person triggers the conditions or not.
I think one of the difficult points for me is knowing whether we're talking about control of the company or whether we're talking about control of the business company. Mm-hmm. Because yeah, the tests that I was alluding to, and again in one of those countries, India or China, I forget which one at the moment, but a person can be deemed to be an associate if he has granted a loan to the other company and the loan represents more than 10% of the net book value of the borrower. And, you know, there can't in reality be that much difference in logic between an associate in that context and a controller in what we're talking about in the UK. Now there are differences in legal format, but in economic substance it's difficult to see a difference.
Yeah, I think it is it's the analysis in places is going to be difficult, and I think it's hard to sort of generalize about it, but you know, it comes down to the sort of facts of the specific situation, I think. And I think you're right. I mean, there is obviously a difference between control of the business, control of the company, but a lot of the guidance does sort of talk about control of the company by reference to you know, decisions relating to the running of the business. So in a way that
you see, in tax terminology, that would be something that I would think is more equivalent to effective management rather than management and control.
Mm-hmm. Mm-hmm.
So we're in a world where different governance organisations choose terminology, and unfortunately there isn't yet alignment on this terminology, which represents a lot of problems for the clients and the advisors.
Yeah, yeah. It's going to be a lot of work, I think, for clients and advisors to work through, as you say, the different levels of analysis, because they don't always align. And we've sort of found that. I mean, in the majority stake test, I mentioned that the dominant influence limb. There isn't any guidance in the UK PSC regime as to what dominant influence means. So we've been saying to clients that, you know, we need to look at the sort of wider context and look at, you know, for example, the definitions of parent and subsidiary undertaking in the Companies Act, which uses similar dominant influence wording. We've been looking at the accounting guidance in relation to that terminology to see whether parallels can be drawn when we're doing the PSC analysis.
Well, if you look at control in the automatic exchange of information and CRS materials, it almost takes you back to, well, it does take you back in relation to a trust to the definitions in the Financial Actions Task Force, which is which in respect of a trust that's a fixed trust is relatively easy to understand, but in respect of a discretionary trust is not so easy to understand. And the definition in Financial Actions Task Force is probably the overriding definition on the tax field, to the best of my knowledge of what I've been able to discover. And when you're talking about a discretionary trust, they really throw in each person who has a role in the setup or the management or the operation or the custodianship, let's say, of a trust, and lump that person with the test of tar that person with being the controller. Mm-hmm. And there is great concern. There is great concern that if the definitions are not the same in different countries, then when all this information that's supposed to be out there to help control tax evasion gets published or gets made available to the tax authorities, you could end up with a multiple number of people all being investigated for not disclosing the same income. I know it's slightly out of turn, but on the trust they'll say that the settlor is the controller, they'll say the protector is the controller, they'll say the trustee is the controller, they'll say the beneficiary are the controllers. Now, if you look at the information that financial institutions have to disclose, if financial institutions know that there are 5 beneficiaries, let's say, of a trust, we'll keep it relatively simple, and each of the beneficiaries lives in different countries, so we've got 5 different countries, it's quite likely that the tax authorities in 5 countries will be making inquiries of those individual beneficiaries on the same amount of money. And that's going to be a major concern.
Yeah. Yeah, absolutely.
So I don't, in the end, I think there are deficiencies in the information on the PSC because ultimately it's giving information to the authorities on everything, but it's not actually saying how the authorities are going to use this information and once they get it. I don't think.
Okay, we have plenty of questions to cover, so we can get back to these points about maybe having a discussion later about what are the main problems with the PSC register. Maybe look at some of the flaws and look at some of the challenges that it poses. But let's look now at we have question 8 here. What is the position when the relevant UK or LLP is held through a trust structure? Since we're discussing trusts, Nick, you wanna?
Yep, sure. And Peter's covered this a little bit, but when you're looking at a UK company or an LLP that is held through a trust structure, there are really sort of 2 stages to the analysis. You need to look first at whether any of the trustees themselves need to be disclosed under the PSC conditions. So, for example, if they held more than 25% of the shares in the relevant company or more than 25% of the voting rights, they would need to be disclosed. And if they are a corporate trustee, say, if one of the trustees is a UK company, then it will need to have its own PSC register. But the second stage is looking at whether anyone else has significant influence or control over the trust itself. And that could include, for example, a beneficiary if the beneficiary is exercising the requisite degree of control. If a beneficiary doesn't sort of exercise that kind of control or influence, they may not need to be disclosed. And if the example that Peter gave of a discretionary trust, if it really is a truly discretionary arrangement and the beneficiaries don't have any say over the running of the trust, then they will likely not need to be disclosed. There's separate guidance from the government on what significant influence means in the trust context, and it's sort of having the ability to make decisions over the running of the affairs of the trust. So things like being able to appoint or remove trustees, or to direct distribution of assets, or make investment decisions on behalf of the trust. It may or it will also depend on the jurisdiction of the trust. So, as Peter said, a lot of overseas trusts will hold UK property, and it will be a case of analysing the trust documentation and arrangements in those jurisdictions to see exactly who has those rights of control or influence. So in some jurisdictions, for example, there may be a protector who has the power to appoint or remove trustees, and that may well be a person who needs to be disclosed as well. As well as looking at those rights, again, goes back to the point that you need to look at whether anyone is actually exercising control over the trust. So they may not have a legal right to do so, but if they're the kind of person who is regularly making recommendations to the trustees which they are following, then that person should also be disclosed.
Okay. Femi, anything to add?
No, it's very fascinating. No, nothing to add. No, I think my attention was caught by, I think both Peter and Nick have covered the fact that a protector in a trust could potentially be a person with significant control, which has flagged some issues for me to deal with offline with regards to that was a very interesting point when it came up. Also, the idea that beneficiaries might have significant control, as you say, Nick, only insofar as it's they have some real persuasive way of making the trustees do what it is that they want to do. Otherwise, then clearly otherwise, if it's purely discretionary, then they have no say. But certainly the role of the protector Yeah, that's an interesting one. Yeah.
Yeah, and I mean, I think it really depends on the circumstances of the particular scenario. So they may or may not be, but it's certainly something that needs to be part of the analysis, I think. So if the protector is exercising those kinds of rights, then the regime does intend for that person to be disclosed.
I struggle a little bit with the beneficiaries not having a right of control, because in a discretionary trust, to the best of my understanding, a beneficiary has a right to force the trustee to properly administer the trust. I think that's the correct legal position, I think, and I stand to be corrected, and if I'm wrong I apologise. But if that is the case, how far away is that legal right from giving the ultimate power of control over the trust?
Yeah, I mean, I think there is a distinction between having the right to have the trust administered properly on the one hand, and having the right to direct the decisions of trustees in respect of, deciding which investments to make or how much of the trust income to distribute or to whom. I think the examples that the government guidance gives is sort of having rights over decisions that direct or influence the running of the activities of the trust, and they do say things like, having the right to amend the trust deed, revoke the trust deed, direct the distribution of funds. So I think, to me, I mean, it is a case of looking at all the person's rights as a whole on the facts. But I think if it's purely that you have the right to make sure the trustee is doing their job properly, I'm not sure that's enough to get you into that category of control.
Yeah, I think you're right.
Yeah, I would agree. I think the point has probably been made in the past that whether beneficiaries have a problem with the way in which the trustees are carrying out their duties, that they would appeal, if you like, to the protector, who would then step in, which would in itself mean that they have some influence, but not necessarily the controlling decision-making powers.
Mm-hmm. Mm-hmm.
What about the situation when the beneficiaries can all get together and, subject to the terms of the trust, decide to have the trust's assets vested, which they can do, can't they?
Which they can do, yes.
Yes. Now, that's a pretty significant power or right. Now, I just think there are a lot of problems here.
Yeah, well, clearly, yes. Yes,
Yeah,
the more we get into it, the more it becomes obvious, yes.
I mean, I think it does illustrate how there is not always a clear-cut answer to these questions, and that's why people have been sort of grappling with the analysis in relation to trusts and other ownership structures, because it's not always immediately obvious how it applies.
That's why I think that in looking at how how to deal with this, if one responds in a manner that's compatible with the Financial Actions Task Force, what it says about control of trusts, then I think one is on firm ground.
Okay, now that we're talking about the problems, what other problems do you see in terms of the legislation, the regulation? I know Peter has brought up several of them. Femi, Nick, any others you'd care to share with us?
I wouldn't frame it so much in terms of a problem, but I think there is a point, in terms of, because it is a new regime and people have been taking different views on certain points, I think there is going to be a period of people adapting to market practice on certain points, and hopefully when some of those issues have been discussed and settled down, that will in some cases make the analysis quicker or more straightforward when there's kind of an accepted view on how to deal with some of the points. I think at the moment, just because there is so much detail in the legislative provisions and in the guidance, you have to look in a lot of places when making a judgment on the PSC conditions.
Yeah, I agree entirely. It is early days. I think practitioners are in themselves getting themselves familiar with the different sources. You advise your client today. You get an interpretation tomorrow. You go back to the client. It is pretty much early days. I think all we can do is keep a close eye on what's required, advise clients accordingly, and then wait to see how things develop.
Yeah, I mean, one thing that we haven't discussed yet is that, I mean, we've all, I guess, been sort of talking so far on the basis that the information is sort of readily to hand and that people are willing to supply the information where required. I think where companies, directors and company secretary run into problems is where they are struggling to get the information that they need from people who they suspect are people with significant control. Directors and secretaries are under a statutory duty to take reasonable steps to identify their PSCs, and ultimately they can send a notice requiring that information to be provided, and it will be a criminal offence for someone not to respond or to respond in a misleading way. So I think that's where the difficulties will be in sort of how far people can go to get the information that they require, because the regime does set out various offences for non-compliance, and it's a strict liability regime. So it's something that directors of companies need to make sure they're getting right and that they're taking all the steps that they can to get the information and have it confirmed.
To be fair, Nick, that's been quite helpful for us. The fact that the guidance has prescribed what company secretaries and directors need to do where they feel there is a person with significant control. That's been very useful for us to actually point out or attach an appendix to correspondence to clients to say, look, here's what you need to do if you don't get the compliance, and then here's what you need to tell the individual would be the consequence of not complying. And the fact that there are criminal sanctions attached to this and that they are strict liability has been useful. In our limited experience to date, has been very useful in getting clients to, the company secretary or the director who is, if you like, the director, but then there are other parties sitting outside of the corporate structure. They'll say things like, well, I really can't rock the boat, and we'll say things like, well, I'm afraid you're going to have to, and here's the reason why. So it has been quite useful to have that level of detail in the guidance, which has helped us so far to give the company secretary, director enough ammunition to go to these individuals and say, you need to step forward even if you don't want to.
Yeah, that's a good point.
Femi, what's been your experience in the company officers, the directors and the company secretaries, if they say to you, well, we don't really know who to ask?
I was hoping you wouldn't ask that question because we get it all the time. Well, basically, we've been saying to them, we start from the start, don't you? Sometimes I intervene and say, look, let me help you out. Let's talk to the directors. So I'll visit and I'll say, look, be frank with me because I'm here to help you, obviously. So look, are there any sponsors? The definition sometimes is a sponsor, a party has a beneficial interest, or my dad's helping out and he puts some capital into the business. There are all sorts of reasons at our level, the market that we're dealing with. There's all sorts of reasons why there is a party who is not known to the company secretary, and we'll start there. And we do say, look, the best advice we can give you is let's approach them and tell them that this is a statutory requirement. We're obligated by law to disclose who you are. Now, why? Well, there aren't, I said this, I don't know, 20, 30 minutes ago, I said, these aren't usually people who are trying to avoid taxation, for instance, or who are involved in criminal activities. I gave you one example of a client who was launching a product, wanted to test the market first, and literally had a bare trust situation in place where they had a nominee, you know. But we had to go to them and say that notwithstanding that, you've still got a statutory obligation to come forward, you know, and you may not like it and it may be commercially detrimental, but we have to do this. And by and large, apart from a few, by and large, people are stepping forward and giving the information. So where it's not apparent, we just have to ask and say, do your best to send out correspondence to individuals who you think may exercise significant control. People who you suspect do, because sometimes, you know, mum has a lot to say about how son's running the business, so therefore we have to ask the question directly. So it has been interesting, Peter, to address those issues from our perspective.
You see, pardon me, where I tend to see things like this is if you have international businessmen using UK companies to invest in third jurisdictions. And the international businessmen are not particularly happy about the third jurisdiction becoming aware or having access to information about their involvement in a triangle of this nature. And that's proving very interesting in conversations as to how to deal with that.
Well, Peter, that's almost precisely what we're dealing with. We're dealing with clients in other countries whose, for instance, they will open up a rep office in the UK, or their children went to university in the UK and they're helping them out to start with while they find their feet. And it is actually helping, because in some cases you've got entrepreneurs in foreign jurisdictions who are simply helping out their children. In some instances, we do come across people who are politically opposed, and then we go, aha, this is part of the reason, the very reason why this legislation is in place, you know, and then we say we need to have that conversation with them. And yes, it's not always a comfortable conversation to have, but we encourage the known entity, the known individual within the entity, to step up to the plate in terms of their obligation.
Yeah, and I mean that person is as well. I mentioned how, you know, if the director send a notice to that person, he is required to respond, but he's also under his own proactive statutory obligation to identify himself, and even if he doesn't receive a notice. So there are obligations on both sides.
But it is a difficult one, Peter. I entirely accept the point you're making, because we get instructions from overseas-based clients all the time, and it's not necessarily, it's got some, ever since the taxation of property by foreign companies, ever since that, it's nothing to do with that really. It's now people wanting to expand their businesses into the UK, and their concern is about, they don't necessarily want their affairs, you know, and we're saying, well, to be fair, I say things like, well, that's tough, because you're going to have to.
And what's the situation? I haven't checked this, so I don't know. But what's the situation if the UK company is owned by a foreign charity?
Oh gosh, I'm backing out on that one.
Is it the government of the charity?
Sorry, I didn't catch the end of that.
Sorry, I said, what would be to be disclosed if a UK company, if the shareholder of a UK company is a charity organised outside the UK?
Well, I think it would, not to sort of avoid answering, but again, it would depend on the structure of the charity. I mean, there are some in the legislation itself. There are certain bodies that have the status of individual PSCs, so certain public bodies like government departments, I think, and various other bodies do have to be disclosed in the way that an individual would. off the top of my head, I don't know if a registered charity in another country would fall into that category. I'd need to check.
No, I don't know.
The ultimate question is sort of whether there's whether there's an individual or group of individuals who are controlling. You know, the general rule is that you need to look through whatever structure there is in the foreign jurisdiction and identify whether there are any individuals controlling above it.
I would think the answer to the question is that the board of governors of a charity would deem to be the persons of significant control, I think.
Yeah. Wow. Yeah.
Yeah, I mean, I think it would. It's something that you'd have to sort of look at the exact governance and sort of work through the legislation. I think it's hard to sort of give to give general answers on those points.
Mm-hmm.
Okay, we have about 10 minutes left. I mean, we can go over per bit. So let me move on with some of the other questions we have. We discussed some of the sanctions already for non-compliance. How about looking more at the expected costs for UK companies to comply with this regulation? What are the expected costs for companies to actually follow this regulation? Femi, you wanna?
Well, I mean, apart from our professional fee. Well, it's an internal exercise in most cases. So, you know, I would imagine that if the company is structured properly, it should be company secretary sending out correspondence to individuals. I'm not saying that's not a cost in itself, because clearly individuals have other responsibilities. It is an additional burden to businesses if you don't have the sort of infrastructure in place to get this done, then clearly you're outsourcing that. So, you know, as I said jokingly earlier, that then means professional fees. But wider, it could cause, to my mind, it could cause some concern from the very people Peter mentioned earlier on. You know, if you've got people who are happy to make financial contributions to start fledgling businesses, but perhaps don't want to be identified, whether that's for altruistic reasons or otherwise, I could see that it could have a bit of a detrimental financial cost on businesses going forward. But essentially, it's an admin cost. I don't know, Nick, what do you think? It seems to me to be primarily an admin cost.
Yeah, I think that's right. I mean, it is an additional admin burden, as you say, and I think the cost. I mean, I think when the government was consulting on it, there were various sort of aggregate figures for the cost to UK business, but I think it really does depend on the nature of the company and its business, and sort of factors like how often its ownership structure is changing. You know, if it is the kind of business where there aren't many fluctuations in the shareholders and it's pretty stable, then arguably, it's just something extra to file a company's house. But if it is the kind of business where there are, quite often investors coming in or out, or the rights that people have over the business are changing, that could be more work. The directors and the secretary are still under an obligation to kind of monitor the situation, so they need to, if they think someone's status as a PSC has changed, or there are new PSCs coming on board, they need to be keeping up to date with that. So it's something to monitor. And then finally, I think it depends obviously on the complexity of the structure as well. So we advise quite a lot of clients in the private equity sphere, and it's it is a detailed analysis in those types of arrangements, and it takes time to work through it. But I think once people get used to doing that, and it will become quicker over time. I think it's just because everyone is sort of getting to grips with all the detail at the moment.
Yeah, no, I'm not being flippant or anything, but most business owners in the SME sort of arena who don't appoint company secretary are already facing burdens. If they don't get their annual, you're surprised at how many annual returns how many companies fail to put in their annual returns on time anyway. And that's, as it is now, that's a relatively straightforward exercise. If you have the authentication code, it can be done in minutes, you know. But as you say, Nick, you know, it depends on the complexity. I mean, we have clients who we are registered office for, so we look after them. But you've got that many clients out there who, you know, don't want to pay the £13 just to go online and check that everything's fine. So it's going to cost what it's going to cost, which is the companies who are not really compliant are definitely going to get themselves into a mess. Those who would seek advice anyway will be told in advance when the confirmation statement needs to be sent in, which should still be the same date that the annual return should have gone in, and the fee hasn't changed, you know. It's compliance. It's an admin. It's a function of compliance and administration. And we'll know this time next year, I suppose, what it's costing businesses.
Yeah, yeah.
I agree. I agree with that. The cost is going to be in those who don't comply.
Yeah, yeah. Who already don't comply. Yes, exactly. Or perhaps they've not been in the habit of doing that. Yeah.
Or who continue not to comply.
Continue not to comply. Yes. Yes, what a shock that's going to be, because if you don't comply now, all you get is a threat of being dissolved. You get told it's a criminal offence, but there's a threat to dissolve. But according to the guidance here, you're looking at imprisonment or a fine if you fail to comply. So that should concentrate people's thought processes. One would hope.
And, you know, given that we're talking about that, about sanctions, you know, are there any options, like if an individual has concerns about appearing on the public register, are there any options available? Is there any way that they can be exempt, or is it pretty mandatory?
There
Nick,
are a couple of... sorry, go ahead.
Go ahead, Nick.
No, I was referring to you, Nick.
Okay. No, there are a couple of routes to consider. One is there's a so-called protection regime where if the individual feels that there's a serious risk of violence or intimidation as a result of the company's activities or their association with that company, they can apply to Companies House for two kinds of protection. One is that all of their PSC information would be kept off the public register. The other kind is that they can stop their residential addresses being shared with credit reference agencies. But for both those types of protection, it seems that it will be quite a high bar to sort of satisfy that test. And Companies House has issued guidance saying that, you know, the evidence of the risk of violence or intimidation will be needed. So we expect that that will work in the same way that the current regime for protection of directors works, in that, you know, they may need police reports of threats of violence, that sort of thing. So that's not really, it does have to be a genuine risk. It's not, you can't just apply for that because you don't fancy being on the register. Aside from that, if someone has concerns from a privacy point of view, really the only way to avoid it is to relinquish control of the company. You know, if someone is happy with a pure, sort of a genuine economic interest with no rights of control, then they wouldn't need to be disclosed. But, you know, quite a lot of business owners do want to be involved in the running of their business, and if that's the case, then they will need to be disclosed.
Yeah.
My experience with Companies House is that I'm going to be generous to Companies House, and that is they're not the slightest bit interested in acknowledging reasonable circumstances for people who filed annual returns late. So if that approach continues, I believe it's going to be very difficult to get them to see the merit of excluding people from the register on these two tests. I mean, I recently had the occasion to try to draw to Companies House, or to draw to Companies House attention that there's now a situation where HMRC won't necessarily pursue a £100 fine if you lodge a tax return late, and
Right.
tried to put the same argument to Companies House on the basis that, well, they're just two different arms of the same government. So why should there be a different approach if you lodge an annual return late to the approach that happens if you lodge a tax return 1 month late? Well, there had to be appeals through all the levels of Companies House with that one, and they said, well, that's a different arm of government, it's got nothing to do with us. So and there were genuine commercial circumstances in this case as well, or I thought so. But so I'm not sure that anybody expecting favours from Companies House is going to be happy.
Right. Let's go with the final question. I mean, Peter, you brought up the international context. How do you see the PSC register fitting in with the automatic exchange? I know you brought it up briefly when you were introducing yourself. How do you see that both of them playing along, or I guess interacting with one another? What's your
Well,
position, I guess?
The automatic exchange of information. If we're talking about, there are really two types of automatic exchange of information. One is financial account information, and the other is ownership information. Well, it's not likely, I don't think, to have any relevance to financial account information, because the banks ask for that information when you open up an account and periodically. But it certainly will have relevance in ownership information, in that if country A asks the UK for the UK to disclose the ownership of an English company, then HMRC will, by definition, have much more information available to share with the other country than what they have now. So I think it will be particularly significant for some countries who are making large number of requests for for specific requests for information. It won't have any relevance in spontaneous requests, but it will in specific requests.
Okay.
But you know, in the end, in exchange of information, it comes down to how good is the register. Let me say, in cross-border exchange of information, it comes down to how good is the register, how good are the people operating the register, and how keen are the people who have the obligation to share the information with the foreign authority to actually share it, and on a timely basis.
Right.
Yeah. Yeah. The human factor.
Any comments on that, Nick or Femi?
No, I agree with Peter entirely. Yes, the human factor. You know, it's yeah, it makes sense. Yeah.
Yeah, I think that's a good point generally about the quality of the register. You know, there isn't going to be as far as I'm aware, there isn't a sort of independent check of the information that's being submitted to Companies House. So you know, it's reliant on companies getting the analysis correct.
Yes. Yes, relying on companies getting the analysis right with no independent check-in. That's very, very interesting. Very, right. You know, the old phrase, "It's an interesting time." Yeah, it comes to mind.
One comment, one comment
Okay.
that's not answering the question. But I think we're going to see a rise in human rights applications as defence against the disclosure of information. The human rights defence hasn't really been canvassed much. But going forward, if information is inappropriately shared about people or about their circumstances, wait for the applications to courts to stop that information under the human rights. arrangements.
Okay.
We